with you.
Yes,
you were going to confer with the petitioner.
Yes.
What were you expecting him to say? Because you were the ones receiving the original results. So if you have to go and confer with the petitioner, wasn't it enough for one of you to go so that one stay around and see exactly what is happening?
My Lord, with the greatest,
the atmosphere.
My Lord, with the greatest of respect, the question is also suggests that the first respondent cannot be trusted.
No.
And therefore, we should have left one person there. I indicated to this honorable court, my lords, that we acted in good faith and realized later that we were deceived. And so, yes, there was that option, but we exercised the option that will allow us to give the petitioner the best of information that was available to us. For instance, my lord, whilst he was there meeting with the returning officer, I was in the strong room. He needed to inform the petitioner what exactly he was discussing at that time, and I needed to tell the petitioner what I was observing whilst I remained in the strong room. So it was important that both of us left.
Doctor, I want to be very clear on some of these issues. Now, you already told this court that you were not sent to the strong room to take instructions from the chairperson of the first respondent. Is that correct? Your presence in the strong room was to see to the cause of the petitioner, but not to take instructions from the first. You were asked this question and you admitted and you said yes.
And I indicated that.
You said yes, you are not to take instructions from the first respondent.
My lord, yes.
So, when the first respondent said, go and consult the petitioner, what were you going to discuss with the petitioner? You were in the strong room for a purpose. He told you to go and consult the petitioner. On what? And what to do?
My lord, on the specific irregularities that we have brought to her attention, and she did indicate also that the reason she was asking us to do so that all the stakeholders, including the MPP, Peace Council and others, could be invited to ensure that we have a credible results before the announcement is made.
But you know that part of your duties in the strong room, at the end of the day, if you are refused to sign, was to indicate the reasons why you had refused to sign.
My lord, it appears to me that there is a particular side of this narrative that has not been very clear. I am saying with the greatest of respect that the forms that arrived in the room and within that room itself, there has been no space whatsoever for us.
No, I don't mean that. I am saying that at a point in time in the strong room, there will be a time for you to indicate your displeasure and what has happened.
My lord, to the EC, we know that, and we had hoped to get that opportunity, but that opportunity was denied us.
Please. Then, you see, would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you are saying is true, you did not help the cause of the petitioner who sent you there?
I don't believe that is true. We were working in furtherance of making sure that the results that ultimately gets announced by the first respondent reflect and represents the will of the people. And if she asking us to consult with the petitioner is part of how we could get there, we were happy to do it.
But then, seriously speaking, you did not take your training seriously. No, please, it's not an appropriate question. I want to be clear. You've gone to do a particular job. Then, instead of doing the particular job that sent you there, you take instructions from somebody else. Then you leave your job. You see, that's what I want to find out. Then you did not help the petitioner.
My Lord, we respect his lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he had, he has answered. He has, in terms of his lordship can have his opinion. That's his opinion to have, and he can have it. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take difference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. But how am I harassing him?
Well, you're harassing him respectfully because the petitioner has indicated that it wasn't just somebody told them that go and talk to the petitioner. The petitioner has indicated that the returning officer...
The witness or the petitioner?
The witness. Thank you for the correction. The witness has indicated that the chairperson, not just any, the chairperson who the returning officer was the person with whom his colleague had the conversation, and on the basis of that, they were sent to talk with the petitioner. And he has given every account of why they thought it fit that both of them should go. Now, so if repeatedly an opinion is being put to him, that is harassment of the witness, and that's not allowed.
My last question.
Thank you.
My last question, Doc. Just by the way, what do you lecture at the University of Ghana? The subject, please.
My Lord, I teach public policy.
Okay, thank you.
Right. I have one more question for you. I want to be clear in my mind. You said in evidence that you never spoke to the chairperson or the first respondent. You said it.
My Lord, I did say I never spoke to her in person.
Yes.
But I do know that my colleague had spoken to her on our behalf.
No. So how did she instruct you? If the person never spoke to you, you have admitted the vote.
My Lord, I am surprised at this question. Well, the reason being that...
Why are you surprised?
I'm surprised because...
the question I'm asking emanates from your evidence.
Yes, my Lord.
So wait.
Wait. Thank you, my Lord. Sorry about that, my Lord.
I'm saying that you have admitted on oath that you never spoke to the chairperson.
Yes, my Lord.
So I'm asking, how was the instruction issued? Is it not a fair question? Why are you?
It is a fair question, my Lord. So why the instruction was issued through my colleague, Rojo Metanono.
Yeah. So
and on the basis of that, we had to comply. Thank you, my Lord.
No re-examination.
Order in court, please.
Counsel, may we know whether this is the last witness for the petitioner? My Lord, we have an application in respect of our request for inspection of certain documents, and the outcome of that application will determine whether we ask leave for a further witness, because we've only filed two witness statements, and we would need to ask leave. But the outcome of the application that we have pending will affect the decision that we make.
Thank you. Yes, Mr. Amenuvo, have you been served?
Yes, my lord, we have been served.
Okay. Yes, Mr. Kotompa.
My lord,
have you been served?
we've been served.
Then, do you have any objection to the application?
My lord's respect, can the witness be...
Oh, let me discharge you. Yes.
Can he be discharged?
Yeah, oh, certainly.
Thank you, my lord. I'm in a hurry to go. Thank you, my lord. Order in court, please.
My lords, with the greatest respect, I mean, I appreciate, yes, but my lords, is it that the Supreme Court requires people to be in a suit?
Yeah, but we insist, it is just an advice. It's nothing. I'm not taking anything away from him, sir.
My lord, the only reason I rise in connection with this is that if the word goes out that whenever lecturers are coming to the Supreme Court, they have to be in suit. Because
Order in court, please.
We are raising the status of lecturers.
Sorry, Mr. Menvo, are you opposing the application?
Yes, my lord. So
Mr.
my lord,
Akotampa.
we are opposed to.
Okay. Then you adjourn it to tomorrow. Yeah. If you have any process to file. Mr. Chika.
No, my lord.
Yeah. Please, we want to. Sorry, excuse me. Please, do you want to have it argued today or you?
yes, my lord, you was filed today and served today. My lord, if you, with the kind permission of the court, get an hour and a half, we can come and file our position. If my lord wants to take us later in the day.
My lord, then we might as well be given the opportunity to file it by the end of the day, and we'll argue tomorrow.
testify in court, please.
The petition is adjourned Wednesday, the 3rd of February 2021 at 9:30 a.m. for motion for an order for production for inspection of documents. If after the motion there is the opportunity for us to continue, we may do so. Thank you.
All rise.
To cross the road, you must use a pedestrian crossing or a traffic light controlled crossing point. If the road has no pedestrian crossing, please stop at the edge of the road, look left, right and left repeatedly until you are sure no vehicles are coming from both sides. That is when you should walk briskly to cross the road. While crossing, keep looking out for approaching vehicles. Do not run because you could fall and be run over by a vehicle. Where available, the footbridge is the safest crossing point. Please use it. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
A good papa.
Janabam, if your apostle, your waist, all your body, you make bazaar.
Thank you so much.
I feel good.
What happened? Janabam! Waiting here from doctor. Where are they?
Pio.
What must I do?
20 cedis.
Mr. Tiabako! Janabam! Yanto Amatoha. Mr. Tiabako. I think she will be 20 cedis.
Hey! Nemo, say we began to come.
Sound so if me Ghana, you can't resist.
They call me UJ. When you need a shoulder to cry, run on my pumpy, so we try our suicide. Let bygone be bygone. I did whatever I'm gonna do, we go straight to stardom. Take you to next level. Energy next level. Back baby, oh yeah. Take you to next level.
I don't go next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Oh, Charlie, that's my friend over there. Hey, Azoto. Hey, Azoto.
Charlie, how?
Charlie, did you go for the test we talked about the other time?
Oh, man, I do them simple.
Oh, you do them?
Oh, I do them.
Hey, Azoto. Charlie, this is great. Oh, guys, pardon. This is my friend Azoto. Another bold, wise person who is just taking the HIV test.
Wow! That's a wise decision, man. Azoto, we a bad man, Kassan. You be the man. You did for what?
That's really a sensible decision. When you
Of course, it's time for testing. It's no big deal getting tested for HIV. The days of stigma are long.
There is life after HIV testing. Be bold. Get tested.
Guess what? We just moved into a new home. The kitchen, the TV and other appliances, this beautiful furniture. Mimi, we buy new.
Everything is new.
Yes, and best part of it, SIC Home Plus has all our content covered. Peace of mind.
For me, security is priority. The SIC Home Plus has my house covered against fire, burglary, family accident. All of this at the most affordable rate.
No need to worry about any health-related issues like cancer, kidney failure, stroke, and heart attack, and many more. All these are being taken care of by the SIC Plus Home.
Hey, Grandma, it is SIC Home Plus Police.
Nah, akabagbanna.
Call on SIC now for the enhanced Home Plus package. SIC, our promises are sacred.
And they call me UJ. When you need a shoulder to cry, run on my pumpy, so we try our suicide. Let bygone be bygone. I didn't see whatever I'm gonna do, we go straight to stardom. Take you to next level, baby, oh yeah. Energy next level, baby, oh yeah. Take you to next level, baby, oh yeah.
I don't go next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
To cross the road, you must use a pedestrian crossing or a traffic light controlled crossing point. If the road has no pedestrian crossing, please stop at the edge of the road. Look left, right, and left repeatedly until you are sure no vehicles are coming from both sides. That is when you should walk briskly to cross the road. While crossing, keep looking out for approaching vehicles. Do not run because you could fall and be run over by a vehicle. Where available, The footbridge is the safest crossing point. Please use it. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority. Guess what? We just moved into a new home. The kitchen, the TV and other appliances, this beautiful furniture. Mimi, we buy new.
Everything is new.
Yes, and the best part of it, SIC Home Plus has all our content covered. What peace of mind.
For me, security is priority. The SIC Home Plus has my house covered against fire, burglary, family accident. All of this are the most affordable ways.
No need to worry about any health-related issues like cancer, kidney failure, stroke, and heart attack, and many more. All these are being taken care of by the SIC Plus Home.
Hey, Grandma, it is SIC Home Plus Policy.
Nah, Akabagana.
Call on SIC now for the Enhanced Home Plus package. SIC, our promises are sacred.
This advertisement has been vetted and approved by the FDA.
Janabam, if your waist or your body make bazaar. Hey, what are you doing? Where you from, doctor? Where you been? What must I do? Mr. Tiabako. Ghana Bar, young Tom to her, after 20 cities. Hey, you know, Nemo, 70 Ghana sound so it may have Ghana. Oh, Charlie, that's my friend over there. Hey, Anoto. Hey, what's up? Charlie, how? Charlie, did you go for the test we talked about the other time? Oh, yeah, man, I do them simple. Oh, you do them? Oh, I do them. Hey, Azoto! I do them. Charlie, this is great. Oh, guys, pardon. This is my friend, Azoto. Another bold, wise person who is just taking the HIV test. Wow! That's a wise decision. Azoto, we are better. The man, you dead for what?
That's really a respectable decision.
When you of course, it's time for testing. It's no big deal getting tested for HIV. The days of stigma are long.
There is life after HIV testing. Be bold. Get tested.
That when they were asked or instructed to go and then consult with the petitioner, that is His Excellency John Dramani Mahama, on some of the observations that they had made of irregularities that were significant in terms of the credibility and integrity of the results. They left in good faith in the expectation that after consultation they were going to come back and then continue with the process as stipulated by law. However, as you all witnessed, that was not to be. Immediately they left. A few minutes after they left the strong room, the chairperson of the Electoral Commission surreptitiously and hurriedly went ahead to declare the results in their absence. Now, she basically ran all the time-honored practices and conventions that were established by her predecessors. There is a precedent that was established in 2012, where the New Patriotic Party agents raised a number of issues relating to the results that were coming in. The former chairperson of the commission, in the person of Dr. Afarijan, called a meeting of all the parties and their agents and the key stakeholders, and they sat around the table address those concerns that were put before him, and then ultimately declare the results. And we were all witnesses to what happened thereafter. The current president brought a petition together with his vice president and the late Jake Obi-Chebilante to the Supreme Court, and it played out for 8 months before the Ghanaian public. So what happened on that day when she decided that she was not going to wait for them, out of respect and courtesy and in accordance with due process of law, to consult with His Excellency John Dramani Mahama before coming back for them to redress the issues, that the concerns that had been raised, shows the utmost bad faith that she exhibited. It also shows that she was determined, and this bears repeating, she was determined that by hook or by crook, His Excellency Nana Addo Dankwa Akufo-Addo would be declared the president-elect of the Republic of Ghana. Now, I'm sure as you watched, there was a lot of, how would I say, questions relating to the so-called Form 13. Now, that is the presidential elections, declaration of presidential results form. You notice, for instance, that counsel for the first respondent on his feet tried to smuggle in from the Form 13, the so-called Form 13, through the back door, because that wasn't an exhibit attached to the witness statement of Dr. Kwesa White. When lead counsel for the petitioner, Mr. Tachuchi Kata, objected, and his objection was upheld, one of the justices of the Supreme Court, to our utter surprise, decided that that must be made an issue with respect to the evidence of Mr. Kwesa White. Dr. Kwesa White, sorry. And through her, the form was shown to Dr. Kwesa White. Now, ladies and gentlemen of the media, Form 13 is not a figment of anybody's imagination. It is a creature of statute. It is in CI 127. Now, Dr. Kwesa White made it abundantly clear, and I am sure this will come out during cross-examination, that what was shown to him was not Form 13. And counsel for the first respondent was in court. He did not object to the fact that Dr. Kwesa White described it vividly as a form other than Form 13. Now, what does that tell you about the credibility and integrity of the elections results that were declared by the chairperson of the Electoral Commission? If you can declare elections on a fictitious form, and I say fictitious advisedly because that form does not conform to CI 127. So where did she get that form from? We will leave that for you in your questioning of the EC, in your questioning of the second respondent, to elicit the information with respect to where that form was gotten from. Then also the venue of the declaration. It came out very clearly that the venue of the declaration was changed without consultation. They sent invitation letters earlier to all the parties, and we were all aware that the declaration of the presidential results for December 2020 was going to take place at the International Conference Center. But because of the lack of good faith and the fact that she was operating from a predetermined position of declaring the results in favor of Nana Addo Dankwa Akufo-Addo, immediately our agents, the agents of the petitioner, left. She hurriedly went upstairs and declared the results in their absence. And now they are in court blaming our agents for leaving, even though it was at her instance that they left. And by the way, you don't need to communicate to two people before your message will sink. she communicated with Honorable Rojo Metilnunu regarding the consultation with the former president, now the petitioner. And so it was not absolutely necessary for Dr. Kwesa White to have had a conversation with her before proceeding to go with Rojo Metilnunu to see the former president. So if you saw the line of cross-examination by lawyer for the first respondent, and then subsequently and unfortunately by some of the justices of the Supreme Court, indicating that Dr. Kwesa White ought to have been present when the conversation took place. That was rather unfortunate. And you saw some of the scenes that played out in court today, where the witness was being harassed left, right, center, because his evidence clearly was against the grain of the narrative that the EC and Nana Adoranko Akufado's lawyers have been trying to put out.
Why both of them left?
That both of them left because they did not want to, they noticed that their candidate was losing. So we are here today in very high spirits. I can see from the, the faces and the body language of Professor Nana Jane Opogajiman and my chairman that we had a wonderful day in court. And I am sure that, in fairness, if this evidence is anything to go by, on Judgment Day, we will be smiling. Any questions?
Doc, from the very beginning, when the EC chair was appointed, your party had raised concerns about her being fair during the elections. And you had a time where you had Dr. Kwesa White and the other representative being in the strong room, going to the EC chair to go and have conversation with her. You've always had doubts about her fairness. When she told you that you could go and meet your petitioner, with this precedence of you doubting her fairness, why didn't you allow one of your representatives to remain at the strong room whilst the other goes? Because you always doubted her fairness anyway.
Right. Now, we did that. The witness himself explained why that is the case. And that was because the two of them played different roles as agents of the petitioner. And it was important that they both, would go and explain the concerns that had been, observed. So, for instance, if Rojo Metilnunu forgot something in explaining to the petitioner, then Dr. Kwesa White could fill in the gaps. And then also, we gave her the benefit of the doubt. We left in good faith because she was performing a constitutional duty. That's correct. And we thought that she would go by the letter and spirit of the Constitution, and that she would also go by the letter and spirit of CI 127, which require that you don't finalize, okay, and sign off the results of a presidential election without the agents of the political parties. These are time-honored principles and conventions that have been established within the EC and within IPAC for purposes of the declaration of results and for the sustenance of the credibility of results. That didn't happen. Yes, sir.
Yes, sir. Thank you very much, Counsel. Having listened to the testimony of Dr. Kwesa White, most of his testimony bothered on information given to him by Mr. Rojo Metilnunu. Would you have rather presented Rojo Metilnunu as a witness?
No, I don't think that matters. The fact is that they were two agents of the petitioner working in concert to advance the interests of the petitioner. And so relying on one agent's information or advice with respect to what to do, for me, that doesn't matter. It doesn't take away from the fact that the chairperson of the Electoral Commission acted in bad faith. Any more questions?
Yes, Doc. A number of very short questions. Number one, listening to you, I get the impression that some of the judges misunderstood the case that was being presented by your witness. Indeed, the witness himself had to, on several occasions, try to address and readdress some of the concerns. Now, these are the people going to pass judgment on the case that you have brought before them. If they have misunderstood you, and on the other hand, you are saying on judgment day you will be smiling, will you indeed be smiling? Number two, indulge me please. Number two, there's a question of harassment of the witness. Indeed, a lot of us watching who are not lawyers and who have always held the court in high esteem, and the judges for that matter, were scared at a point when we saw the witness in a kind of a direct confrontation with some members of the bench. And indeed, the lead counsel did same on the question of harassment, which matter you have repeated here. Is it safe for you and your case with that kind of a direct confrontation with the bench? And finally, the former president had attended to...
I think you are going too far. Can we take your questions one at a time? I'm even beginning to forget your first question, right? So can you, let's take your one at a time. Can you summarize, crisply the first question, and I'll take that and we proceed to the second one.
Okay. So the first question has to do with some members of the bench misunderstanding your case.
Okay.
Are you worried about that?
I don't think so. As an experienced practitioner, I am quite sure that they understood what Dr. Kwesa White was saying. I am pretty sure there was nothing unclear about the evidence that he gave. All right. Judges are allowed to ask questions for clarification. What they are not allowed to do in terms of the law and ethics of judging is to descend into the arena of conflict. Now, as to whether they descended into the arena of conflict, I will leave that to you to judge.
Number two, on the question of conflict and harassment, what we saw in court, for a lot of us who don't understand the court processes, is it healthy for you and your case?
I don't think that detracts from the probative value of the evidence that has been given. Okay, he did a good job of standing up. Okay, as far as the issues that he was called upon to address are concerned. He was very credible. He was eloquent. And you heard the judge saying that he stopped lecturing.
Number three, finally, the former president, whose case it is, had attended to the court diligently up to the end of last week. The whole of this week I haven't seen him. Just asking, where is he? And how is he?
The former president is well, and carrying on, the business of being the leader of the NDC. Of course, the party chairman ably represents him on a daily basis. In fact, chairman has never been absent, and I am sure, and of course, the running mate is here as the person who was on the ticket with him, and she has not also absented herself even once from court. So there's no issue about representation. The former president is not required to be in court on a daily basis in order for his case to be heard. Otherwise, if that were the case, I'm sure the judges would have been asking where he is. Since they haven't asked, it's in order.
Doc, you've put in a request to inspect some documents. Earlier, I had seen a process that was directed at the Electoral Commission. If you could explain how this is different from that one. And secondly, looking through the list of the documents, are those not documents that are supposed to be in the custody of the petitioner through his agents? And I also recall that this issue came up in the 2012-2013 petition as well.
Yeah, that is so. You recall that we filed a notice to inspect the documents. The notice was duly set on the respondents, and the first respondent in particular has custody of all those documents. And by the way, this is to inspect the originals. It's not about us not having the documents. We want to authenticate what was provided to us and what has been put on the website of the Electoral Commission, and that motion will be heard, tomorrow. So I wouldn't want to take up some time on that one.
Look, thank you. I'd like to help to break down one of the issues to the understanding of our viewers. It's got to do with the witness using the words asked and instructed. To ask is not the same as to instruct somebody. He used the words interchangeably. He doesn't work for the EC and therefore should not have been seen to be taking instructions from the EC. And if the EC actually asked him to do something, he wasn't compelled to do that. You've spoken about acting in good faith. Yes, as my brother asked earlier, you had expressed some unfaithfulness in the EC itself. And so where did the good faith all of a sudden spring up from?
Okay, thank you very much. On the question of the difference between asking and instructing, I think Dr. White used instruct in order to emphasize on the fact that they accorded some level of respect because she is the authority, the ultimate authority. She's a returning officer under the Constitution, and all the political party agents in that strong room with, if you like, on her instructions, on whatever direction she gave, to the agents. And so the fact that he used the word instruct does not in any way, suggest, okay, that they were taking instructions from her instead of taking instructions from His Excellency John Dramani Mahama. Remember that the petitioner was their principal, and as agent they worked, directly to the principal and for the benefit of the interest of the principal. And so I don't think that it makes any difference whether they took instructions from her or they were asked to go and consult with the former president, and they duly complied. As I said earlier, they were acting in good faith. Little did they know that the person they were dealing with was acting in bad faith, or intended to act in bad faith. Yes, and they came back after 45 minutes. Okay, and the question is, why could she not wait? Okay, we waited. This was on the 9th, right? We waited 2 days for the results. We could have waited another hour for the results to be credibly, compiled and released to the people of this country. Yes, that, yes, but the thing is this, my brother, okay? She is the only constitutional officer that you have to work with. She is the sole constitutional officer that you have to work with. So the fact that we express, some reservations about her even-handedness and so on prior to the elections, doesn't mean that we could have stayed away from working with her. And we decided that we're going to work with her in good faith. She decided otherwise. Thank you very much.
Let me do that quickly. Wait. I'm saying, it's your court and then a Samoa. And Debia Samoa can say Electoral Commission. As our body team possess. Kwambia sno Obama Nana Akufo-Addo aye president no enne wohwe obemfo Kwesa White nensa mo de beto aye court enim no ede di pefe se edu baby kura no odada enipe na musifo ano mo dem ho se omko no omne aye John Dramani Mahama candidate na eno ngodi nkita ho esan nsem bia no mapega enko ye wore mo ewi ekire no omusi abonte amukoya no enu sima ninu anamiensa kra no okoye and oko declare elections no edika o se hunu se na wenye dika kata Ghana for na say election e declare no awo conference center and so on okatra say wɔn nkɔ ne no nkɔdi nkita wɔn mo fam a yɛmmra no wɔn si abɔntea enu 45 minutes ɛna wɔn kɔɔ na electoral commission dɛ wɔ a wɔn kɔ declare adeɛ no ɛnɛ nso ɛmi sɛ form bi a oyusu ɛde declare results no form no wɔ ha ɛnɛ yɛnya judges mu baako ebisa form no nfa electoral commission dad no na yɛ ne sɛ nka wɔn bisa ba obisa no yama no ho kwa because na ade no any evidence so ɛnɛ yɛnya judge ɔno ɔpɛgya sɛ ɔnhwɛ form yi na sɛ form wei no baabi ɔwɔ yɛ sɛ ana form a ɔde baayɛ no saa form no ɛnyɛ form a ɛwɔ mmerɛm form a ɛwɔ mmerɛm no ɛnie CI 127 a ɛkyerɛ form ko a yɛmfa declare results no ɛnti sɛ wɔn use saa form na declare results na results no ɛyɛ papa ana ɛnyɛ papa ne etwa to okura ɛyɛ atete a ɛnɛ Dr. Kwesa White ɔte adaka no na yɛsɔ na basa yɛsɔ na TV yɛsɔ na chi adentie sense asɛm ɔka no ɔkyerɛ kwantrene ne yɛsi wɔ dɛm hɔ ɛma yɛ lead council ɛyɛ owura tatuji katakora sɔre ka sɛ wei ɛyɛ atete a ne aburoni frɛ no harassment no ɛmfata say ebesi Supreme Court ba mu ina mu hui but ɛna ne esi no yɛ NDC for the M say yɛ ni agye akɔni yie sɛnea ne yɛ pɛ no nokora no akyɛ ase edi na enim sɛ yɛ kɔ enim no nokora na nkasa ɛbɛdedi yɛsan file application bi a yɛ pɛ sɛ yɛ kɔkɔtwɛ electoral commission documents ɔde ma yɛ na original na ɔde ma yɛ no yɛ pɛ sɛ yɛ kɔkɔhwɛ ɔkyena ɛna Supreme Court bɛhwɛ no ɔhwɛ no nso a yɛ to say for edemase.
Thank you. Do summary.
Yeah.
Propaganda. Colleagues, good afternoon. We want to share with you a few thoughts as the court rises to resume sitting tomorrow morning. First of all, we on the side of the second respondent view today's proceedings as a very excellent day in court. And it's an excellent day for us in court because the issues are beginning to unfold one after the other before the eyes of all Ghanaians. Remember, this is a petitioner who came to court praying or invoking the powers of the Supreme Court that the results of the 2020 presidential election, when properly collated, come to a point where nobody got 50%. And therefore they are asking for a rerun. And you would expect that they put witnesses in the box to advance this argument or to provide evidence that buttresses this. Today, as you've seen before your very eyes, their witnesses are here making claims of bad faith, which claims are questionable, now raising questions of the venue of the declaration, now suggesting that in one breath they say they never saw the Form 13, in another breath what is being tendered before the court they say it's not a Form 13. Now today, three key matters have been settled in our opinion. The first is this fallacy that was being initially expressed and amplified through Dr. Michael Kwesa White, that the chairperson of the Electoral Commission instructed the representatives of the petitioner to leave the strong room, and on their blind side some numbers were put together and announced. We are beginning to see clearly that fallacy at best is something that cannot stand cross-examination. You will notice that it's not just an interchange of words, instruction and asked. And I want you to take particular notice. When you read the petition No, sorry. When you read the witness statement, the witness statement says we were asked. Check the definition of asked. Now, in the witness box and under oath, he seeks to amend that and escalate the claim by saying they were instructed. And that's why you find the Venerable Akoto-Ampah did not take too much time in his cross-examination. He asked one key question. He says, I put it to you that you know that you cannot be instructed by the chair of the first respondent. And you heard under oath, they could no longer tell that on truth. He said, yes, we cannot be instructed by the chair of the first respondent. And we are clear in our mind that that fallacy has been settled, and the court will take notice of it. That it cannot be true that the chair of the Electoral Commission would instruct and that the representatives of a candidate will obey that instruction. Indeed, questions as put by the council that you selected an option, you elected, and that you were derelict in your duty. That is what happened. And we are very happy that that is being settled. Another matter that is being settled is the attempt of the petitioner and his witnesses to surreptitiously question the results by discrediting their own agents. Notice that initially from the beginning of the case, they sought to make an argument that numbers had been cooked up and that the EC's computations were incorrect. Yesterday you saw the very skillful general with a calculator now arriving at 4751, 4751, 4751. Today they tried another tactic by trying to suggest that there was something wrong with the results that their agents had certified from the polling stations through the constituencies to the regions. And in cross-examination, you saw it clearly come out, and it being settled that they could not use the back door to discredit their very own agents who certified the results from the bottom up and then claim that somebody from National had said that the figures did not add up. Another matter that we believe the court will take notice of is the attempt by counsel, and we believe successfully, to settle the dereliction of duty of the persons who were nominated by the petitioner to go into the strong room and assist in the collation of results. Now, please check. The MDC and candidate Mahama accredited 4 people. 4. In the end, 2. Now, this is after they had done their parallel collation in their collation center with the TV screens, one of which you saw Mr. Mahama pointing that they were winning or that they had won, and then their press conferences. After certifying or accrediting 4, 2 went into the strong room and left. After all 16 regional returns had come in, and 13 of them had been certified by Rojo Metilnunu, who was the leader of the 2. And notice something interesting. Dr. Kpesawa says that Rojo certified one of them in error. I'm sure as we go further, that will be dealt with also in addresses. That these representatives of the candidate ended up sitting there and even certifying some in error. It's a different matter that will be dealt with. But what is also instructive to note is that, and I think one of you asked a question, you are not judges. Many of you are not lawyers. But you even spotted it. But how can you claim to us from the beginning that this EC commission, we don't trust her? There are so many problems with her. In your statement, you say she's doing the bidding of the NPP. Then you claim that she instructed you to go and consult your principal. And out of the 4 accredited people, the 2 who were there, both left. Why? And it was interesting listening to them. They said that they wanted to go and fill in the gaps. I'm sure you heard them. That they were going to fill in the gaps. One of the key things that is becoming interesting is why Rojo Metilnunu himself did not mount the witness box, take the oath, and say that he was instructed. We believe if he had done that, he would have been caught for perjury, because he cannot take an oath and tell an untruth. And that is why they have resorted to Dr. Kpesawa, who now admits that he never spoke to or was never spoken to by the EC chair, yet he was a subject of an instruction and he was instructed. But the one who heard the instruction, the one who went to the office, is alive, is available, but refuses to take the witness box. We think that it is becoming very clear that as these matters are settled, and as we connect it to the principal issue of did anybody get more than 50%? Was the declaration in breach of Article 63(3)? The key questions will now come out and be answered. Now, another matter that we need to draw your attention to is this Form 13. There was this claim to suggest that the document that was shown to the witness was done through the back door and was not Form 13. First of all, let me make this point. Every practicing lawyer knows that after cross-examination, the bench has room to ask questions for clarification. And you hear the learned justices always say that we want to understand this one clearly. So to create an impression that when they ask you questions, they are harassing you, is part of the NDC strategy to begin to poison the minds of the general public against the bench. Because they can begin to see from the questions and the answers that they are giving, the gaps that are showing up in their case. Remember, they have already said that they think that this court is not a balanced panel. They have already been arguing that they have not been treated fairly and that some of the decisions don't make sense. And today, they are furthering that by trying to poison the public by saying that they are being harassed. The bench has the right to ask questions. We believe that when our witnesses get into the box, they may even be asked questions. Nothing wrong with that. Now this Form 13, which Mr. Pesawait under oath claimed did not have room to state reasons for non-signing, is on page 62 of CI 127. I want to encourage you, my colleagues in the media, pick a copy of CI 127 and look at it. The last column on your right says, reason if refused to sign. That same column is available on the original summary sheets . At the constituency level. Why? Because it amounts to a certification of a complaint that will go up to the higher level. So if all your 275 constituency persons did not certify any complaint, and on your original forms, you have gone ahead to certify all except Sebiwi also, which later Roger Metonunu now certified in the strong room and you claim he did it in error. You don't come with a bad case now to come and say that there was no space on the form to fill in a complaint. I'm sure you all heard it. The blatant untruths being told before the court. So we are very, very clear in our mind that the matters that the court has settled for itself, which is to determine whether or not nobody got 50%, whether or not the declaration was in breach of Article 63(3), as compared to the matters that they are seeking to attest to today, show clearly that what they've been saying, when put in the box and put under oath, is difficult to defend. We'll take your questions if you have any at this point. Yes. Go ahead, sir.
The import of any cross-examination is to discredit the petitioner. You explained why your cross-examination by your lead counsel was short-lived, but do you think that he succeeded in discrediting the witness of the petitioner?
Well, as I've mentioned, the court in its final judgment would express its view on whether it believes it was successful or not. But as you all watched and followed on television, you saw a witness under oath say that there's no room to state reasons and be confronted with versions of it that show that there's room to state reasons. You also saw a witness who in his witness statement had earlier said that I was asked and I changed it to mean instructed. And then when put under further cross-examination that, but you know you cannot be instructed, admits that, well, actually I cannot be instructed. You saw a witness who claimed he had been trained yet claims that somebody instructed him to act contrary to the training that he had been given. So it is not for us to determine whether or not it succeeded. You saw it, and we are hopeful that the bench will come to a conclusion on that at the end of the day. If you look at the case they brought and the witness they brought, was this witness here to prove that nobody got 50%? I'm not sure you heard that witness prove that. Was this witness here to prove that Article 63.3 had been breached? I'm not sure you heard that. This witness came at best to say that he was instructed together with Rojo to leave, and later when put to further cross-examination admitted that he cannot be instructed so to do. That was the main thing that this witness came to know. As to how that answers the question of 50% plus 1, I'm sure the bench will decide.
Also the question of the when and where of the declaration on the 9th of December. On your side, at what point did you know that the declaration was going to happen at the headquarters of the Electoral Commission?
I never saw in any of the pleadings, no paragraph, in which they raised an issue with the venue of the declaration of the presidential election results and suggest even faintly that therefore amounts to an illegality or an unconstitutionality. They never raised it even in their pleadings. So when you put a witness in the box and you have made pleadings, the government of your case is that nobody won 50%. You have made pleadings, the government of your case is that the declaration is unconstitutional. And you bring a witness and the crux of his argument is that I was instructed to leave. And they did the declaration in a different place than they had earlier announced. Maybe it's our imagination. We look forward to what the court will say on that. What I find interesting is a comment made by Dr. Ayine here, that the exchanges between them and the bench today has no probative or has no effect on the probative value of the evidence they have put before the court. I find it very interesting. And I agree with him. We are hopeful that in a possible, because this case can only end two ways, either we win or they win. In an event that they do not win, they do not come back to cite such matters, that this is why, because they have told you that they know from their 25 years of practice that it has no effect on the probative value of the evidence before the court. And we all look forward to that. My colleague Nanabi will do a quick key summary for us.
Okay. Abusanfo we de madama ye bebo no tew. Ne kan ena ayeda etoso enso a ye ba court ene Dr. Pesa White ehye adakam ne toto na no yenya ye hu kwan a ne nsem a na o ka no ensisi so obusano asemo a na o se ne colleague Rojo Metonunu inso yamfa no ama metena adakam ne toso mienu ade ba ko ese pie ne se obani eye Pesa White eko grantee interview oni media for kasai na o se emanu 390,000 ye de account na adodan kwakufu ado de ho Ashanti region ene ebeda di se enso na ya tro akohwie na odi adentia saa asem no omanka emo krata omo de beto eye court anim no ebiem se na omo kase osha regions no any enema ankoso ye widespread irregularities just enema abato mankoso ye no ene ye sabeto edi se omo agents enema na musifo a omo wo e regions emu 13 edumiensa ena esign na emu bie no so a otro se no wo asemboni bi e wo ho a oka ebie na ne beto edi no so se agent nso anombo National Collation Center hoi eye Rojo Metonunu ordinance share emanu dumienu ase eye krata from 13 ordinance ehyasie ansa na umufri ho ade ba ko esa beto edi enanso ne se opani Pesa White se eye isi che Madam J Mensa e share omo se omo free eye EC headquarters no money omo presidential candidate enkodi nkomo abusuafo asemwe ene se hu se no so mu orem na yakofisem san se wo a yatete wo ye agent wo obi anamusi ni wo be ye adwuma obi esi de na nipa a nanu bia no mo no esi ni so oye kofini onye na adwuma ye oye obi o ye bias na o ka kira wo se free ho na gya wo adwuma wo ye ho
na wo so wagye na di ena ye hu se no so esa ebosirimuka na yakohwie ena ye se hu so se eye opani pesa hwai se eye ono ane hu nipa ono ne ye adwuma meja metonuri osi kata ni bi odne sa sha ase no osan ye no ana na adwuma na se mu hu se wa ye mfumso adenti nipa wa ye mfumso nya fo no mo ametra da kam sanse oboa ehu kakra bi enso ehye honom ebiem se wohwe enkoma esa koso enenso a ade ba ko aye se hu ye ene se moye agent mienu mo fantitiem ye de munya mu ba be gina honom ama eye omampani dada mahama na mo se bibi twetwe mo aso a esi den ena mo kase mu mienu nyina no mu firi ho na mo akọ ebo apayo omo bo asabre no na eye from 12 year free regions eba no emu dudu na aba amo mahu se omo pani a omo di na chi eye former president mahama no wadi ntwo wadi nkuguo ntina ose oko nene ade ba ko a esa ye anigye awomram se ye tutu eye dance ni bia no a eye adat from penifo etimi nso busansem ensemfo no ba ko a eye efiri opani papa get tokuno ebusa say okay from 13 wo so afantitiem wo ho bi pen o se am ho bi pen ena ode ne dia ekuta no ekere no ode kire no o se enye no a ne nimre nim abusia eno so ya sa cham se aya trokese eye CI 127 bi ne se okọ eye page 62 and 63 a sample of the form 13 no ebi o declaration of presidential resource form enye abusuafo etini omo sabe gina afidie echi sa kan ye se eni mremu no omo boa eno so ya kohwie kesia eno so ebeto edi na ne kura no so be kaya eye judge Penny Obapa Mariama Owusu busa nyembi ka muye mienu ejade na mufi se bibi twuma so kra ba ko pe enkachi no no hwe ne yekoso omanya anuye ensama justice yawapo ebusa say okay mujumadi a mudi nyina no muye agent now do you act on the instructions of your principal and answer on the instructions of the isina on the mudi say eyen shama mo say o say isina asemo ka mudi so ana se ba sa de na ka me ko se duma ye de hye wonsa no ana wato ne pa hwi ana waja onu mako eho openi chachu kasa o kan ye nyame no nukuri ne mo ya enya fe enya kasa eho tie kra etimi ka cha jadi point and penfo say they are harassing your witness. Very unfortunate statement. And ABM Justice Mafusab and so Ebusai said who will say one for when you push ye and who easy chair and one instructor one can be unsure. It took a ben of see Nipan Faso instructor so and Pow, medium and who easy chair, Nemum, a young colleague, Rojo Metunum, and a catcher say, a year is say, a young co. Now, journalists, my name is Busasema, a Mudupa, and one am the baby. Say, a Brebiano Munya, Quenya Biana, easy Musupano, Muchina Boso, Muyen Hufi. Na esi den obi amun jinidi na yatete mu agent mienu na yede mo akona kachi se mu konko jire mu former president Bahama na mu mienu nya se mo jam laptop so ho o konso so bu phone so ansa fa charge anko anadu ma na se meni ena phone obi etu kwanko ne charger kon wo de wo so kwakoda baby 2 days 3 days o ko refuge charger etu phone edum went mene ni power small na eni nkomo Musu amunyi ni panini ya musu mumi enu nyamukọ na ese nsem ni nyano akwa ye anadwuma anasem enukura wo ni se omudi ntwo omudi nkuguo enti oso mo pe bibi na omudi katakata omani adom a court ahyɛ sɛ ɔkyena ɛna ɛbɛhyia abusuafo sɛnea mesrɛ mo no sɛnea daa meyɛ no mɛsrɛ mpanyinfoɔ a ɛka yɛn ho ɛwɔ ha general secretary of the ruling New Patriotic Party ɛyɛ ɔpani John Buedu ɛwɔ yɛn nkyɛn wɔ ha lɔya Nana Adwoa Adobia nso ɛwɔ yɛn nkyɛn ɛwɔ ha ɛna ɛyɛ yɛayɛ campaign chairman Mark Menu nso ɛwɔ yɛn nkyɛn wɔ ha sei alɔyafoɔ mehu lɔya Lenin nso ɛwɔ yɛn akyi mehu ɛyɛ national chairman nso na ɛwɔ ha sei chairman Blay nso ɛnɛ bɛka yɛn ho lɔya Akotampao I'm boy Juma pa lawyer Frank Davis, lawyer Yawopon, lawyer Kwaku Sifi, lawyer Adodapa, lawyer Shelam Kapremo, lawyer Victoria Bath, lawyer Ochre Ajkum, lawyer Dr. Ernest Owusu Dapa, lawyer K. Amwa. Omunyina eboa amadwumadie na koso mehu lawyer Lenin nso ewa ha sei eti abusuafo nyame kyerɛ obi bia lawyer Joyce Boateng nso eka eye aloyafo a omo eye nyame yadom a ɔkyena yebe hyia biem ewo kota nyame hyia mo
well spoken.
So those were the two press conferences held by the petitioners, spokespersons for the petitioners' lawyers, as well as the spokespersons for